everyone. Welcome to the debate we're going to have tonight on Commonwealth and human rights. I would first like to begin to welcome Corinne up, who's going to talk a bit about housekeeping rules, so we all know what to do in case of a fire and that kind of thing. So Corinne, please.
Okay, right. My vital first words. My name is Corinne Lennox. I'm a senior lecturer in human rights here at the School of Advanced Study and co-director of the Human Rights Consortium, which hosts the MA in Understanding and Securing Human Rights, of which two of our distinguished panel members are currently students. Thank you all for coming tonight. For the housekeeping messages, in the unlikely event of a fire alarm, we ask that you exit by the stairs that you came up to the first floor by us, and out the round doors, circular doors to Mallet Street, where London School of Hygiene is. Secondly, if you need to use the facilities, the toilets are just through this door and to the left before you get to the main staircase. And last but not least, and very importantly, please join us afterwards for a reception, which will take place in the room just behind us, the dust room. Hope you enjoy the debate. Thank you.
Thank you, Corinne. As you know, hopefully at least, the motion tonight is this House thinks that Commonwealth commitments of human rights are just for public relations. So a very thought-provoking debate indeed. I would like to introduce also Richard Bourne, who's the coordinator of this debate. It's also a debate series, and he's going to introduce our main speakers here today.
Well, thank you very much indeed, and like Corinne, a big welcome to everybody who's come. We really appreciate this. This is the third in a series of challenging debates, which the Roundtable Journal, which is the Commonwealth International Affairs Journal, has been stimulating in university cities. There have already been ones in Birmingham and Exeter. There is stuff on our website about them, including a YouTube. Tonight we do have video capacity here, and the speakers have all signed a consent form. If, however, after the end you decide you wouldn't wish to be involved in video, please speak to McKenna, who is one of the organisers, along with Cassandra, who's been doing so much work to put this event together, and they can expunge you from the YouTube. Otherwise, I have nothing very much to say. The idea of the series is to encourage young people, students, and the academic community to think more seriously about the Commonwealth and its different roles. They're not all about human rights. One of the debates was to do much more with the United Kingdom. The one in Birmingham is the Commonwealth preventing the United Kingdom from dealing with the past and moving on to the future. And there's going to be a Brexit-related one coming up elsewhere. There are three others planned: Cambridge, Nottingham, and Belfast. All I have to say now is a big thank you to you for coming, and of course especially to our speakers and our chair. Our chair is one of two people who've been doing all the work for this event, Cassandra Soderstrom. She and McKenna Giacome have been are both graduate students here at the School of Advanced Study. And we have on the platform, proposing the motion, Professor Joshua Castellino from Middlesex University. He's done a lot of work on human rights issues, particularly regarding minorities and their legal access in Commonwealth countries, particularly in South Asia and in the Pacific. And he's also done significant work in Africa, so he's got his hands dirty doing this stuff. He knows it. Next to him is the seconder who's supporting the proposition, and you will see it's Cara Priestley, and she's a graduate student here doing human rights, I think. On the other side, leading the opposition, is someone I've known very well for a long time, and that's Colin Nichols, QC, who's done a lot of important human rights work himself on issues like extradition as a working barrister. He was heavily involved in the process by which Commonwealth governments agreed to separation of powers in the Latimer House Principles in 2003. We were both in Abuja on that occasion, and I remember him celebrating. I think that some people would say that it was perhaps too early to celebrate, but anyhow, that'll come out in the debate. And then supporting him is Dahlia Mitchell, a good Commonwealth citizen from Canada, who is also on a graduate student on the current course. So that's everything from me. The roundtable is funding a reception outside afterwards. There should have been a banner, but it seems to have got lost somewhere in Senate House. But I can assure you that we're very, very pleased you're all here. And over to our chairperson.
Great, thank you, Richard. Now for a bit of structure of the debate so you all know what to expect. First we'll begin with 10 minutes from the proposing side from Joshua, who will introduce the motion. Following that, Cara will give up to 5 minutes of her statement. Then we will turn to the opposing side, and Colin will begin with up to 10 minutes, and then Dahlia will follow with up to 5 minutes as well. After that, we will open it up for a bit of discussion on the floor, see who agrees, who disagrees. If there's anyone who wants to raise a point, please feel free to do that at that time. After that, we will hold a vote and see basically what the result will be from the debate, what you all feel. And then after that, I will announce the results, and then we will enjoy the wine reception that both of our housekeeping and Richard Corinne have been talking about previously. So the wine reception will be in Jessel Room. So I just think we're going to let Joshua take it away now with his up to 10 minutes.
Thank you very much. Welcome to this debate. I think you'll find that this is a really straightforward discussion, and we probably don't need all the time that we have, but we will go through it nonetheless. I mean, essentially, when you think about this proposition, the Commonwealth commitments for human rights are just public relations, and I would put a ... and not even consistently at that, is probably how I'd put it. A couple of caveats. We are not saying that the Commonwealth is not relevant. That's probably a discussion for another day that you might want to have a debate on. Neither are we saying that the Commonwealth doesn't do human rights work. Essentially, what we are arguing is that the work the Commonwealth does do, when it does it, is essentially largely out of public relations, and not really because it's trying to create a mechanism through which the inherent dignity and rights of every individual globally are protected. That's going to be the thrust of our argument. And I think Cara and I have thought through some of this, and I want to start by setting something of a scene here. If you start by looking at the question of, well, what exactly are the Commonwealth commitments to human rights? I have to admit that I've done about 20 years of academic research. I had to look them up. I wasn't quite sure. If you ask me about the Universal Declaration of Human Rights, I can quote it to you. If you ask me about obscure articles in the International Covenant on Civil and Political Rights, I could do it. Commonwealth Charter, I had to look it up. And I had to search for the human rights mechanisms in it. I was actually quite surprised to find there were some. So the whole idea that the Commonwealth has commitments to human rights, yes, there is some on paper. So I thought, oh, maybe my argument's weak here. I'm going to be arguing this case against Colin, who is a human rights barrister and has done significant work on human rights. And it's to be lauded, the Suring case, for instance, of 1984. But I think you'll find that the work that Colin has done has actually been towards protecting the inherent dignity and rights of individuals. It's been about creating meaningful change in the lives of victims. It's about creating meaningful change in the legislative, judicial, and all kinds of administrative mechanisms that are there to set up human rights. I don't think you'll find that human rights in the Commonwealth. So basically, what are the Commonwealth commitments towards human rights? So then I thought, well, maybe the next thing to do is to think through the practice over the years. And when you think about the practice over the years, you find it's really mixed. There has been some events early on in the history of the Commonwealth where there was a genuine reaching out to try and construct effective mechanisms, to create constitutional processes, to support the creation of effective public institutions. Was human rights high on the agenda? I think I'd probably concede that it probably was at that time. The question really is it now as high on the agenda as it then was? Also, what kind of human rights were we talking about? I think I'd like to just set down a little bit on what I think human rights are, first of all, because we are arguing that the Commonwealth really doesn't pay adequate attention. So for me, human rights are an attempt to create a legislative, judicial, administrative mechanism that guarantees to individuals and groups the indivisibility of their human rights. That means their economic, social, cultural, civil, and political rights. Yes, there was early engagement of the Commonwealth with the human rights agenda, but it was largely civil and political. So it didn't necessarily address questions of economic and social rights. Right to food? Well, no mechanism on that. Right to sanitation and water? Not much on that either. Development, oh yes, the Commonwealth did address development, but not from a human rights perspective. It was much more with regard to the creation of public mechanisms and processes and projects. So where was the human rights then? So when you think about human rights today, I would argue that they are really about legally binding standards that are accessible, that are implemented through a range of different mechanisms. Through administrative mechanisms, through judicial mechanisms, through legislative mechanisms, so that an individual or any group affected and impacted can go to a court, can engage civil society and seek some form of redress. And I think Kara's going to pick that point up a little bit more as well in terms of monitoring processes. These rights are basically largely negotiated at domestic level and weekly monitored at international level. So you think Commonwealth, transnational, maybe it does some monitoring? No, actually you'll find it doesn't. It doesn't really do that kind of monitoring either. So you might think this is just maybe a harsh criticism. So let me set out to you what I think would be evidence of meaningful engagement with human rights. I've got 6. Naming and shaming. Traditionally, this is the instrument that human rights international bodies use a lot. The Commonwealth has done some naming and shaming, but only on occasion. There has been no reaction, for instance, from the Commonwealth to Theresa May's recent attempt to trying to undermine Britain's role in the Council of Europe, or to trying to put forward the argument that somehow British troops, when they are abroad, should be immune from prosecution. Those are likely to happen in Commonwealth theatres. So what is the level of commitment there to naming and shaming? Well, technical cooperation is often the other way of doing it. Technical expertise, expertise on legislation, expertise on public policy, but there hasn't been a concerted strand in Commonwealth history that really highlights that particular aspect. Then you might think, oh, well, what about financial aid? Maybe the Commonwealth works closely with DFID, and maybe the Commonwealth, if it was genuinely committed to human rights, would try and direct the extent to which DFID funds countries who are not obeying or not adhering to human rights standards, but there isn't a real link there either. Then you think, well, perhaps they do cooperation and promote South-South exchange. Now here you do find evidence, and the strategic plans talk about this evidence. And there are very good stories on gender, and very good stories on youth, and very good stories on development. But guess what? They're framed as youth, gender, and development. They're not framed as human rights. So these are essentially responses to questions that states have. They're not about trying to create and uphold a system to protect the inherent dignity and worth of individuals. What about facilitating discussions and pursuing an agenda at the UN? The UN has mechanisms. Is the Commonwealth present? I haven't come across it in any meaningful way. And nor does the Commonwealth use its good offices to promote exchanges on human rights. So human rights and Commonwealth, well, I don't really see a meaningful engagement. Let me pause for a moment there and tell you a little bit about what public relations are about. So public relations will be defined as the professional maintenance of a favorable public image by a company, other organization, or a famous person. When you look at Commonwealth history, you see that it actually adheres to this. The Commonwealth, for instance, has a lack of consistency in naming and shaming. Why? Because on occasion it's useful to name and shame, but on occasion it's best not to do that because it might affect the public image. The Commonwealth has a resistance to headlining human rights issues. The strategic plan, the latest one, doesn't use the term human rights. Yes, you'll find it in the fine print when you look under it, but it's not going to headline it because the club doesn't really want it headlined. So you don't find that. There's a discomfort generally in the Commonwealth on taking strong stances because there's a real attempt and a real fear of trying to undermine state sovereignty. The states in the Commonwealth assert their sovereignty time and time again. The Commonwealth is an awkward club because it has a historic legacy by which you don't really want to be trying to trod on people's state sovereignty. So then the extent to which the Commonwealth can really get to grips with human rights issues is compromised as a consequence, because the human rights violations occur within states. So if you're going to criticize a state, you are necessarily going to impede its state sovereignty, and that's an uncomfortable conversation if you're in the Commonwealth. It's not if you're at the UN, it's not if you're at the Council of Europe, but in the Commonwealth, you best tread carefully. You don't want to be accused of neo-colonization here. So again, that means there's a structural reason why the Commonwealth can't take it on, but instead, it needs to have some fluff around human rights. And the fluff that exists really is a fluff to prove that it has a public conscience and a public image. Because you can't possibly be talking about any of these issues around development, youth, or women without talking about human rights. You need that human rights as a ballast there to justify why it is that the Commonwealth has resonance even today. But that's what it is, folks. It's basically public relations exercise. It's a useful enough rhetoric to call upon when it fits, but it's often very easy to discard. It's not meaningful in the way in which the institution operates. It's not meaningful in the way it spends its money. It's not meaningful in the stances it takes. It's not really meaningful even in trying to further the cause of using the immense wealth of experience that exists within the Commonwealth to further that particular notion of human rights. So as a consequence, what you have is a club desperately seeking relevance, and one of the key issues today is human rights. So you need to have some pronouncements, but what you will find are the pronouncements are getting more and more muted. The statement at the end of the last significant Commonwealth Heads of Government meeting didn't have the words human rights in it. There was some mention, and you could certainly extrapolate the concept, but human rights as a concept, human rights as a term, it's problematic language for most of the states in the club. Most of the states in the club will not want strong pronouncements from the Commonwealth. There's a throwback to an imperial guilt. That means that states are reluctant to use it because they are afraid of being accused of trying to perpetrate standards that are Western, and we're back into the whole debate about the universality of human rights. So best leave it alone, best find some convenient language, best convince everybody that it needs to be thrown in from time to time, best pick some examples, but beware, pick the examples that don't affect your national interest. Thank you very much.
And now, Cara, can you take it away?
Thank you.
5 minutes.
Okay, so I'm going to make 4 points which prove that Commonwealth commitments for human rights are nothing more than mere window dressing. And these 4 points are as follows. Firstly, that there's a lack of enforcement mechanisms within the Commonwealth for ensuring human rights. Secondly, that there's a lack of resources allocated to human rights as well within the Commonwealth. Thirdly, that Commonwealth human rights provide no extra added value to other international bodies such as the UN. And lastly, that the Commonwealth confuses its commitment to the rule of law with human rights. So on to my first point, that Commonwealth commitments for human rights cannot be taken seriously considering the lack of enforcement mechanisms that exist within the system. So while the Commonwealth may espouse values of human rights, what can we actually pinpoint that show that it's anything more than just rhetoric? Well, it's true that the Commonwealth Charter was established in 2013, which is at least a statement from the Commonwealth that human rights matter. But unfortunately, the Commonwealth hasn't always followed up words with action. So, for example, when the Royal Commonwealth Society drew attention to the human rights abuses in Uganda, Sri Lanka and the Gambia, it was told that these were the internal affairs of those countries. And when the Eminent Persons Group suggested a Commissioner for Human Rights, this hasn't been adopted. So, if there's no interest in following up on these findings, perhaps the Commonwealth needs to admit that their commitments to human rights are not in fact genuine. In fact, since the Charter was signed, Uganda and Nigeria have increased their persecution of LGBTI individuals, as has Cameroon, and India has upheld Section 337 of its penal code, which criminalises same-sex activity between individuals. So, and these are just a fraction of the human rights abuses that are being committed right across the Commonwealth. So I would ask the Commonwealth, what is the value of your values? Can you actually implement them? Because at the moment there's currently a mismatch between words and deeds. And the limitations of the Charter are really summed up by the Nigerian spokesperson in the Senate, who said that the fact that the Commonwealth of Nations makes any law or signs any charter doesn't necessarily mean that we must accept. Homosexuality has become an illegal practice in Nigeria, and no Commonwealth law or charter can make us change this. And this statement really highlights the problem with human rights in the Commonwealth. Its commitment to human rights just aren't taken seriously because countries such as Nigeria know that realistically there's nothing that the Commonwealth really can or will do in order to uphold human rights within its member states. And this is partly because there just aren't enough enforcement mechanisms. So sure, the Commonwealth might gain some positive PR by talking about human rights, but really it's just business as usual on the ground. And this leads on to my second point, which is that the Commonwealth's human rights commitments also can't be taken seriously, given how little money and resources it pumps into its own human rights unit. So Perna Sen, who was the former head of human rights unit at the Commonwealth from 2008 to 2011, has stated that during this time she had just 3 staff members and a budget of $225,000. But in contrast, the Economic and Political Affairs Department has 40 to 50 staff each and a budget of millions. So here we can clearly see the priorities of the Commonwealth. And just to give a slightly more recent update, The Commonwealth Secretariat Financial Statement of 2016 to 17 doesn't even list human rights as a category. Sure, it might be included in another category, such as technical assistance, but even this constitutes less than 0.5% of the budget. So ultimately, one cannot have an effective and meaningful system of human rights without the means in place to do it. And another important question to ask is, what added value do Commonwealth human rights give on top of existing systems such as the UN? So while the non-binding Universal Declaration is backed up by binding human rights treaties, there is no such equivalent for the Commonwealth Charter. And indeed, the UN already gives us the Universal Periodic Review, special rapporteurs, and binding human rights treaties, to name a few, but the Commonwealth hasn't even been able to agree on appointing a Commissioner for Human Rights. And my final point is that the Commonwealth confuses its commitment to the rule of law with human rights. Because while the Commonwealth can claim to have taken some strong action against member states when they fail to adhere to Commonwealth values, the majority of the time this only happens in situations of a breakdown of democracy, such as in Zimbabwe in 2002 and in Fiji in 2009. So while they did act quite strongly in favour of human rights in 1995, when they suspended Nigeria after the execution of the environmental activist Ken Saro-Wiwa and 10 others, since then it hasn't suspended any countries for their human rights record. And the Commonwealth Eminent Persons Group have raised this issue themselves. So in their aptly named report, Time for Urgent Reform, they validated concerns over this issue, stating that the Commonwealth Ministerial Action Group has rarely, if ever, addressed an issue unless it involved an unconstitutional abuse of government. And the very fact that a body within the Commonwealth itself is criticising the Commonwealth on its record here is important. In addition, in 2012, Britain's Foreign and Commonwealth Office report stated, somewhat diplomatically, that it would like to see the Ministerial Action Group address a broader range of human rights and make a larger contribution to raising human rights standards across the Commonwealth. Thank you.
Thank you, Cara. And with that, we'll move to the opposing side. And Colin, if you wouldn't mind starting with up to 10 minutes.
I think we have to begin by realizing that the struggle to achieve effective human rights, make them available to the people, is a very long struggle. And full achievement is not likely to be reached either in my lifetime and indeed in the lifetimes of all of us here. It's a very long struggle indeed. And that any effort that can be made, however small, should be treated as an effort of value, however much its shortgoings. The human rights commitments, Commonwealth human rights commitments, are really, if you look at them closely, goals which the member states wish to achieve. So they're not achieved already, they are to be achieved, and an effort has to be made to achieve them. But to suggest that they are mere public relations, a public relation exercise, is really, when you come to consider it, nonsense. Failure to abide by human rights, failure to abide by human rights standards is not going to endear any country either to fellow member states or to its peoples. And so failure to abide by these rights is effectively a denial, is bad public relations. And even supposing that one state happens to not abide with its commitments, then that doesn't mean to say that all states do so or have done so. Now, if these commitments are not a public relations exercise, what are they? What are states doing when they're making these commitments? The first is that they genuinely make these commitments intending to achieve those goals, depending on the resources that have they available and the conditions in those countries. The second thing is that they wish to remain members of the Commonwealth. They wish to remain members of a family to which they have belonged for a long period of time, with the same values, the same language, the same heritage, and so on. And they want to do that One, because they generally wish to remain within the family, and secondly, because they want to secure the benefits that come from being a member of a family. And if you consider the various Commonwealth commitments, human rights commitments, amongst those commitments is the commitment of member states and of the Commonwealth Secretariat to help countries to achieve those ends. And so the benefits of being a member of the Commonwealth, benefits of having the assistance, the technical assistance and the like that is given by being a member of the Commonwealth, those benefits are something which causes countries to remain, and those commitments that have been made are not public declarations, they have a much sounder basis. Now, the commitments, if you consider in the United Nations Declaration of Human Rights, there are some 30 human rights commitments. In the Harare Declaration, there are 16 commitments, and each of those can be divided up into various areas. So there are a whole host of rights that we are considering, and in each country, different standards and different conditions exist, which cause people to cause those countries to have difficulty in achieving the goals. And so these are things that have to be considered. It's one thing in this motion to say, well, the Commonwealth commitments are not being effective. It's another thing to say that because they're not being effective, it's because they were initially made because it was a public relations exercise. Nothing of the kind. These commitments were born out of the Universal Declaration of Human Rights, which was the result of the Second World War and all the atrocities that occurred there. That is the basis of it all. That is something that needs to be considered. Now, as Richard has said, in 1998, I participated with a number of parliamentarians, judges, lawyers, and legal academics in a colloquium, which was really a meeting, which was designed to draft a framework for the implementation of the Commonwealth principles, the Commonwealth values. And basically, it was a framework of the separation of powers, but it included all sorts of things, like the appointments of judges, the independence of the judiciary, the ways in which the different organs of state would have to relate to each other. And over a period of 5 years, we all worked, civil service organizations, together with the Commonwealth Secretariat, to get the document, the framework, adopted by heads of government. And heads of government adopted them 5 years later in 2003, and they eventually became part of the values of the Commonwealth, and of course are now to be found in the Commonwealth Charter. Now, a lot can be said, and a lot I know will be said, that that framework, those principles now in the Charter, haven't really made very much progress. The Commonwealth Secretariat works to achieve what it can within that area, and there is a toolkit to help countries in implementing the framework, the printed out of my House principles. But how far it goes is very slow, and there can be criticism as a result. But that doesn't mean to say that the countries which adopted those principles, that necessarily that they did solely for public relations. They clearly didn't. They adopted those principles because they believed in them and they were goals to be achieved. And so that is something which needs to be borne in mind very carefully. Don't throw the baby out with the bathwater. Mechanisms are not good. CMAG doesn't have the powers which it should have, and there are people who believe the powers should be increased. But be careful about that, because all these are subject to negotiation. Violations of the principles, human rights principles and like, they can all be reported to CMAC. But what is the result? You don't want to throw all the countries out, and no country is perfect when it comes to human rights. You don't throw them all out. In some cases, of course, they don't get expelled. What they do is they just leave of their own accord. But most importantly, of all those countries that have left the Commonwealth, all I think I am right in saying at the present moment, except Maldives, have returned.
Zimbabwe. And Zimbabwe.
I'm sorry?
Zimbabwe.
Oh, Zimbabwe, of course. Zimbabwe, and that'll be coming back, no doubt, very, very quickly indeed. But if that is the situation, that they all come back, they're not coming back for public relations. They're coming back for benefits of the work of the Secretariat, the partnership of fellow member states in achieving the goals and realizing the commitments which they made.
Thank you so much, Colin. And then, Dahlia, would you like to take it away? The Commonwealth is an organization comprised of 53 states, states varying in size, location, and leverage, but linked together based on common heritage, common language, and common legal structures. Human rights are an essential component of the structure. The Commonwealth represents the interest of the state, but it also represents the interest of the people and the rights and the over 2 billion people living within the Commonwealth. One of these issues of which it represents is on the concept of child marriage. Within the Commonwealth, 8.8 million girls get married each year before they turn 18 years old. The members of the Commonwealth recognize that this is a human rights issue and agreed to address it through the Kigali Declaration. The Kigali Declaration gives national human rights institutions a comprehensive framework to use in their efforts towards eradicating child marriage. It draws on the knowledge and experiences of the countries belonging to the collective to assure that it can be implemented domestically, to have an actual positive impact on girls, and to reduce the number of girls getting married, and to support girls who are already married. The Kigali Declaration improves the rights of women and children within the Commonwealth. Another area that the Commonwealth plays a critical role in is education. The Commonwealth Scholarship and Fellowship Plan provides scholarships for people from across the Commonwealth to attend university. It allows them opportunities to further their education and to improve their socioeconomic status. The Commonwealth Education Trust focuses on teacher development to improve primary and secondary education. Improving education systems and increasing funding available to students improves the economic opportunities available to the citizens of the Commonwealth and serves a purpose far greater than public relations. Through funding and training, the Commonwealth is doing its part to assure that people have access to the right to education. The Commonwealth, through its Secretariat, is able to contribute to reports on human rights and to engage in discussion on human rights issues. Because the Commonwealth has access to human rights experts, it is able to lend assistance and strengthen the voice of small member states in international human rights mechanisms. For instance, the Secretariat provided assistance to Grenada to assure that it was able to prepare its human rights report for the Universal Periodic Review, to provide financial support, and to provide guidance on how to implement the recommendations. Through its training and technical assistance, the Commonwealth is able to improve the process of reporting and implementing human rights compliance within its membership. The Commonwealth Heads of Government meeting is happening next month in London, and it brings together all the heads of governments from around the Commonwealth. But it brings together more than just heads of government. Through its business forum, the People's Forum, the Youth Forum, and the Women's Forum. It provides these groups with a platform to identify key issues, discuss challenges, to form partnerships, and to put pressure on the heads of governments to address these concerns. The Commonwealth provides a forum for citizens to engage in dialogue, to understand what the key human rights issues are, and to allow the heads of government to create solutions that can be implemented at home based on their sovereignty. The Commonwealth Human Rights Program provides
provides a program for police to be trained and made aware on human rights issues within their work. The Secretariat works to improve awareness on human rights issues including human trafficking and gender issues. The Commonwealth commits its members to abide by their agreements. It provides states with resources, citizens with improved economic opportunities, and civil society with an opportunity to hold nations to their commitments. The Commonwealth of Nations serves a structural, an economic, and a practical purpose to improve human rights within each nation.